well, we're going to start on and move on with the program here and kick things off with our first phone call for the night. And welcome to LawCall. On the line holding, it's Ted. What's your question this evening, Ted?
I have been retired for years, but I got hurt on the job, and they still pay for my medical, but they've been wanting me to settle. And I told them to give me a figure, and they said, no, I would have to give them one. How does that work?
Thank you so much for calling. Your advice. Either one, you want to weigh in here?
That's a loaded question, as all of them are.
Yeah.
So it sounds like Ted has already settled his indemnity benefits. So you are entitled to 3 benefits under a workers' compensation claim. You have indemnity benefits, medical benefits, and you have death benefits. And thankfully, Ted did not die, so he's not getting that.
Okay.
So if he settled his indemnity benefits, the only thing that's left is his medical care. Well, what's going on is that the insurance company now wants to get Ted off of their books. He's cost him some money over the years. So what Ted really could do, he probably needs an attorney to do this, but Ted could go in and he could ask the insurance company for a cost projection of what they're going to pay for the future. What medical treatment is still on the table according to the doctors, how long is that treatment going to last, and what's already been done. And you could take those numbers that have already been done and you could take that future medical care and you could evaluate it out under our equations to figure out what's the value of the rest of Ted's life, essentially. It's a sad analysis, but it is what it is. So that's the best way you can do that on a medicals only claim is let's figure out what's left to do, how much is that going to cost under the fee schedule, and send out a settlement demand.
Okay, and I bet there's somebody out there probably listening and taking that advice. Would you, the tips that you just gave Ted, would you suggest someone try this on their own, or they definitely probably want to hire an attorney?
I hate to be a lawyer and I'll say it depends, but I would always say that you should get an attorney for a workers' comp claim. I did not think that going into this job. I have not always done workers' comp. I've done a lot of different types of law. But an insurance carrier's job is to get you off of their books. And they might treat you right, they might do the right thing, but the first chance that they can get that hook of liability out their mouth, that's what they're going to do. So you definitely need an attorney to make sure not only that they're doing what they're supposed to, but also that they're not doing something they shouldn't.
Now, can Ted stick it out? Can he keep going?
Yeah,
And
you
say
can
right
stay.
now,
You can stay on the medical side of the workers' comp claim as long as you want to. But the longer it goes on, what the insurance carrier is banking on is that they can find a way to get you off of their books. They can send you to EME physicians to try and say things aren't causally related. They can start to contest all of your medical treatment where you need to file necessary motions to compel that treatment. And they can just make it difficult on you to the point where you say, I don't want to be on comp anymore, and they will greatly dewould what your claim is probably worth.
Jonathan, I had a question for you. I only deal with workers' comp, at least in my arena, if there's what's called a third-party claim. Would you tell the viewers how workers' comp is different, though, in terms of attorney's fees or what you can recover for?
So workers' compensation law is all housed under the Workers' Comp Act. Workers' compensation law says that we only get 25% of our fees, whether that's through settlement or a verdict. Now what's important, a distinction between us, we don't have a jury trial. We have the commission that houses 8 administrative law judges. We'll appear before them, and that judge will make a determination if they think they need to go above a rating. I'd have never seen them go under a rating. I think you're mainly getting 33% on your fees, probably higher if you have to take up an appeal. On the third party aspect, if you're at work and let's say one of your co-employees goes through and they do something that causes you to sustain an injury, well, that's just a pure workers' comp claim and you're confined to those 3 things. And what's important about workers' comp, unlike you, is that we don't have pain and suffering.
Right.
That can create tremendous damages for an insurance carrier. For us, carriers behave the way they do because they don't have the pain and suffering consideration. So that's one of the more unfavorable points of law. One of the more positives for us is that we don't have a negligence standard like you do.
Right.
You can be completely negligent at work, and if you're doing the job that you're assigned to do, and it's in the course and scope of your employment, you're okay.
You're covered.
You're okay. So it's a trade-off.
You know, they say workers' comp is for the worker, but it's kind of really for the employer, don't you think?
I think it's definitely for the employer. So when they changed the laws, they crafted it in a way to say, you know, we have a fair trade-off. We won't consider your negligence, and we won't consider the employer's negligence, but you don't get pain and suffering. I'd much rather have the option of pain and suffering than to care if my client was negligent or not. Let the judge figure that out.
Good point. Good point.